Hey, everybody. Thank you so much for joining us today. We're going to be getting started here in just a couple more minutes, but we have a very large turnout, which is super exciting. So welcome. So I was just giving everybody a few minutes to join in and get started, and we'll be on our merry way. Just to kind of set the stage. We are scheduled to be able to spend an hour together. This is the Breaking Down Barriers, USCIS's clarified path to extraordinary ability classification. And I see that, okay, so I'm gonna have to juggle between multiple screens, but when we get to the Q&A section, I will definitely be taking questions from the Q&A panel. I think we're good on sound check and everything, but if there's any issues, send me a message in the chat or the Q&A panel, and I will do my best to multitask and track those as well. But I see we already have some questions coming in, so that's wonderful. Okay, so let's go ahead and get started. My name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law and the host of the Sophie Alcorn podcast. I wrote a column for TechCrunch for 4 years, a weekly immigration questions column called Ask Sophie. And from there, I wrote a best-selling book, which is available on Amazon. It's called Ask Sophie, The Founder's Guide to Visas and Green Cards. I believe as a mom and a meditator, and just that's been my life experience existing in the world, that I think we should create a world in which every person has the chance to grow up and achieve their dreams and work in their flow state and be at that intersection of where, you know, their greatest passion meets the world's greatest needs. And so that is one of the reasons why I love working with people in tech and aspiring startup founders and people who are building companies. It is so exciting to be on the leading edge of abundance and advancement of our human civilization. So I'm very excited to be here with all of you today and to share my knowledge and hopefully some helpful insights into all of the new changes that are happening with USCIS and provide some context. We have a lot of people, so it's really cool. So if you have a burning question, I ask you please to put it in the Q&A panel now. There's probably going to be a lot. I love doing questions. It's like being on a game show, and I have to answer as many as clearly and succinctly as possible. So it's really fun for me, but I'm going to fill up the whole hour, and how much I spend on the presentation is going to depend on how many questions there are. So if you know you have a question that's beyond like what are the 4 new improvements that USCIS is making, feel free to just put it in the Q&A panel now, and that'll give me the greatest chance of getting to it on today's webinar. So that's me. I do have to do my lawyer disclaimer because I am a lawyer. This presentation is an educational service by Alcorn Immigration Law. All information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. And if you do need to consult a knowledgeable professional, of course, my team and I are here for you at Alcorn Immigration Law. The QR codes that you see, that's our consultation link. So click on that if you want some one-on-one time with our team, and we would be delighted to support you. Our team's been growing. This is not even the full team. I've hired like 5 people this year, and it's really exciting. And I need more pictures of all the guys we hired because we have multiple men on my team now, which is really exciting. So we're trying to create a more diverse and inclusive environment. But everybody who works with me is a passionate immigration professional. We're a remote distributed team. I'm based in Palo Alto, California, and Silicon Valley, and have several team members here as well. But we also have folks in Texas and other parts of the United States. And we actually just celebrated our 9-year anniversary since I incorporated Alcorn Immigration Law back in 2015 when I was working out of my kitchen. My kids were 1 and 4, and I was like, oh, maybe I'll start a law firm. I'm going to be a founder too. So 9 years and over 4,000 successful cases completed. So it's been really, really, really exciting. Okay, let's dive into the reason you all are here, USCIS's updated guidance on the EB1A extraordinary ability criteria. So USCIS has just released new guidance clarifying the EB1A. The guidance is already effective and it took effect on October 2nd. So this could be super helpful and potentially even a game changer in certain cases for your green card journey. So it's really, really exciting and good. And if you also want my predictions about the election, you can put those types of questions too into the Q&A panel. I don't want to get ahead of myself, but if there's interest on that, I can discuss how these things could potentially change over time. But right now, we still have over 3 months of President Biden remaining until about January 20th, when the new inauguration happens. So this is effective. You can use it now. And it's definitely helpful. Okay, and I would ask that everybody please use the Q&A panel for questions as opposed to the chat, just so I can stay organized today. Thanks. So what are we going to do today? We are going to dive deep into team awards, now counting towards individual achievement, how past memberships can strengthen your case, updates on published material requirements, and new interpretations of exhibitions in non-artistic fields. So it's really good. It's really exciting. It's not like some, it's very specific things. So if you have evidence in these categories that didn't previously qualify, this could unlock your ability to use these evidentiary criteria. And one of the questions I often get from people is when I'm doing like consultations, talking to folks about if we can take their case and how strong their case is, and if they have enough evidence yet, or if they need to do more before we can start working together. But one of the questions people frequently ask me is like, Sophie, do you charge by the criteria? Absolutely not. That is not what I believe in. I believe that you should have clarity and predictability as to pricing. So everything we do is flat fees, even for RFEs, and it's to put your best foot forward in a case. It's not for evidentiary criteria. I think that can lead to a lot of RFEs when people are being low budget. And I just want to help make the best arguments possible for you, whether there are 3 criteria or 10 criteria plus comparable evidence, whatever. Like, the point is to build the strongest petition possible for you. So if you're going to add something in because of this, we're not going to charge you extra. It's just part of our standard fee. So, okay, let's dive into what this whole thing is anyway. A lot of you know this already. Everybody in tech became super experts in EB1A since last Thanksgiving, I feel like. Some of you are probably here because you've heard of this guy on Twitter called Didi, who was one of my clients, and he blogged a lot about his journey. We did a webinar together. So that kind of like came to fruition a year ago because I was at TechCrunch Disrupt last October, helping him finalize his case, and it became approved shortly thereafter. And so he blogged about his journey as a founding engineer to get an EB1A, and now he has his green card. And normally everything my clients tell me is 100% confidential. I can't disclose it, rules of attorney ethics, but in this case, he's kind of like a thought leader, and he shared his story in great detail. So when he did that, because he has a bunch of tweets that go viral, when he did that, everybody started talking about, oh yeah, EB1A, how are you going to build up your criteria? So the EB1A, for those of you who are new to it, is an employment-based first preference immigrant visa, aka a green card pathway, and it's issued to people who are not yet green card holders, who can establish they have extraordinary ability in one of 5 fields: sciences, arts, education, business, and athletics. And so at Alcorn Immigration Law, we work with a lot of people in tech and startup entrepreneurship. And so we're often blending these categories together to show that somebody is at one of these crossroads. So it's a very, very powerful tool. It's a very powerful tool because it is the fastest way to get a green card without a million. Actually, it's probably one of the fastest way to to get a green, it's one of the fastest ways to get a green card, period, full stop. It is certainly the fastest employment-based green card preference category, so faster than anything with perm by several years, faster than EB2 because the EB1A refreshes every year, every October, when the new fiscal year starts for the government and the visa bulletin resets. And certainly for people born in India, this is absolutely the fastest pathway to a green card, and it can make a huge significant difference in the number of years you wait for a green card. And now, because there is heavy green card demand for people from all parts of the world, it can even save, like we work with a lot of people like founders or people in tech, and they're sort of comparing, should I do an EB2 national interest waiver self-petition, or should I do an EB1A self-petition? Because they don't want to rely on their employer for a green card. And like, even if you were born in Germany or something, like Germany is where my mom is from, it could save you like a year and a half or more to be able to get an EB1A rather than an EB2 NIW. So there's a lot of benefits. And also you don't have to marry anybody, and you don't need $1 million. There's no lottery. It's like actually just based on what you accomplished in your life. So it's more clear, like if you put in the right inputs, hopefully you can get this. Okay, so who qualifies? So you need to have evidence of extraordinary ability in one of those recognized fields that I mentioned, typically somewhere in like sciences, engineering, entrepreneurship, business. That's typically our fields, although we have helped people in other fields. You either need a Nobel Prize, which nobody has, so that's fine, except the people who have them, of course, and good to them. And we just saw some of those announcements starting to come out, like with AlphaFold and things. But for most humans who are getting EB1As left and right, and you might be on this webinar because you're like, well, I signed all these letters of recommendation for my direct reports who are getting these, but like I'm still waiting for my green card 20 years later, and I'm smarter than these people, so why don't I have an EB1A yet? So like, yeah, there's probably people smarter than you who've gotten EB1As, and probably people less smart and less accomplished than you who've gotten EB1As. And how do they do that? Well, you just need to show that you meet at least 3 out of the 10 criteria. You need to show that you're going to continue working in your field of expertise. You need to do something that's going to substantially benefit the United States in the future. And that's that whole like final merits determination thing that people talk about. But you don't even need a job offer to do this. You can be completely self-petitioned, independent, and use this to change your jobs, change your life, change where you live, and build a company that you're really excited about. Just have the freedom to take a sabbatical and ideate on new technology or something you might want to build. So it's a very, very powerful tool. Okay, so what is this new USCIS guidance? And I see the questions coming in the Q&A panel, so that's fabulous. Thank you so much. I'm excited to get to those. So the new guidance on the EB1A eligibility criteria, which as I mentioned, became effective at the beginning of the month, this changes the policy in 4 areas: team awards, past memberships, published material about you, and exhibitions. And let me just put this into the full context for a minute, because I think it's important to just lay the groundwork. So there are actually 10 criteria. I typically don't use 2 of them because most of my clients usually are not artists. And there's 2 specifically for artists. One is like commercial success, selling tickets and stuff for things you created. And then the other is artistic exhibitions. So that's actually one of the ones we're going to be talking about. But if you limit yourself to the 8 others that have to do more with business and tech, they're very, very comparable to the O1A standard. And the O1A is a visa for extraordinary ability. It's usually issued 3 years initially with 1-year increments. It's not a green card. But if you can get an O1 first, and not everybody can or wants to, a lot of people have spouses with H4 work permits who are employed, and so those folks don't want to get an O1 first. They just want to go straight for an EB1A. But if you can get an O1, it like reduces surface area for attack on an EB1, because The USCIS policy manual specifically states that you have to give deference to prior approvals of extraordinary ability by USCIS, including the O1. So these 8 criteria that the O1 and the EB1A have in common are, have you won, and this is like my really, really short summation. This is not the legal language. There are whole laws, regulations, policy memoranda, statute. There's so much that is, you know, more than this, but my summation is, did you win prizes? Are you a part of groups that are hard to get into? Did somebody write something about you or your work? Have you judged anybody? Not are you a judgmental person, but have you like officially judged if somebody else is an expert like you? What have you created that's original? Have you written stuff? Did you have an important role somewhere? And did you make a lot of money? So like in human speak, those are the actual things: prizes, associations, press coverage, judging, original contributions, authorship, leading in critical role, and high salary or remuneration. So we're going to drill down into several of those criteria before I get into the questions and answer more like high level things for folks. Okay. And just before I do that, let me just move one of my windows, and this will give me greater visibility into what's happening. But yeah, I see the questions coming in, so that is fabulous. Oh my God, we have so many people in this webinar. Thank you all for joining me today. I hope it's super useful for you. And if you have any more questions, please do put them in the Q&A panel. Okay, so let's just dive into this. Team awards. I am helping somebody right now whose team got a technical Emmy for working on some infrastructure that was used for streaming. And, you know, it's a huge deal. Probably like everybody in America has heard of this product. And her name, fortunately, is on the award. But we were really concerned when we took the case this summer that we wouldn't be able to get through the awards criteria because USCIS had been inconsistent in their adjudication standards on this, with some officers saying from time to time, if you're on a team, it's not good enough, you're supposed to be the expert. Or you could see this in the music context of like, sure, that band got a Grammy award, but that person was the drummer, not the lead singer, so they don't qualify. So that was wrong, and we had different language to fight that if and when it happened. But now USCIS has like officially de-risked that, debunked that, and they're explicitly saying that you are allowed to meet this criteria based on your membership in a team for both the lesser nationally or internationally recognized prizes, as well as for any other types of awards for excellence in your field. So it's really exciting. Over here on my other screen, I have the specific language, and it says, nothing precludes the person from relying on a team award, provided the person is one of the recipients of the award. So yay, it makes sense. If you're on a team that won an award, we get to use your award. And then they went on to have a footnote, which states, in general, qualifying awards include team awards where each member receives a trophy, certification, or medal, appears on the podium or stage, or is specifically named in the awarding organization's announcement of the award selection. Examples include members of a musical group who receive an award and relay team members who appear together on the medal podium. Mere acknowledgement from the award recipient does not constitute receiving the award from the awarding authority. Now, that being said, like, we get awards in venture capital approved for startup founding teams all the time. So like if you're a founder or a founding engineer, we've already been able to get venture capital awarded to the company, counted as an award. So that's already been established, and fine, we can do that if that's you. But this is like relay races, you know, team Emmy awards, other things where like a bunch of people's names are being listed, even if you're not the lead singer in a band, it can now work. So it's quite exciting. Now, the next area where they release new guidance is the area of past memberships. So there is new guidance on the definition of memberships in associations in the field of expertise. Most specifically, past memberships in relevant associations are now considered. So this is also really exciting because it means that like if you were, I don't know, a fellow in some organization and you were active like 2 years ago, but you know, you didn't want to keep paying your dues, but you still got into the organization, we can still use it now. And specifically in the policy manual, the new thing that they said related to that is USCIS determines if the association for which the person claims past or present membership requires that members have outstanding achievements in the field as judged by recognized experts in the field. Okay, so they're including past memberships explicitly, which is very exciting. And once again, there's a footnote and it says, well, current membership is not required to meet the plain language requirements of this criterion if the petition is not accompanied by any recent evidence. The length of time since membership may be a consideration for whether the person has sustained a claim in a final merits determination. So that's that catch-all Kazarian case analysis that makes this a non-determinative process, right? Like you can have 3 categories, but you still might not make it through. And that's because they're looking at like everything together. And so what they're saying is like, yeah, if you have past memberships, that's cool. They can be one of your categories. We don't want some big gap where you like stopped being prolific and you're not an expert anymore. So if you are in that situation, then we definitely want to make sure we can bolster your petition with additional recent evidence. It doesn't have to be the memberships, but it has to be something else showing that you're still active in your field. Now, the next thing that they changed is published material. And this isn't really this is something where they deleted text. They didn't add text. So basically they deleted this sort of like erroneous thing that's not actually in the law, where it says where adjudicators were incorrectly requiring petitioners to demonstrate that the published material had to demonstrate the value of the work and contributions. So that's completely gone. So in the olden days, you might get an RFE saying, yeah, sure, you were in Time magazine, but it was an ad for your, not an ad, but it was just like a little write-up about your technology. It wasn't that you were like Time Person of the Year, so therefore we can't use it because it didn't say that you're valuable. But they're not allowed to do that anymore. Right now, it's simply a 2-step analysis for published material. It's like, step 1, did people write stuff about you? Step 2, is the place where they wrote about you a professional publication, major trade publication, or major media publication? So it's really like, do articles exist and are they in qualifying publications? If yes, move forward. There's no threshold about the value of your work. Okay, so now we're going to go to the next slide. So the last one, and then I'm excited because there's a lot of questions and I think we're going to have a good solid half hour to go through them. So it's very exciting. And I'm going to start with a Q&A panel and try to get through as many of those as possible. And so if you put stuff in the chat window, please make sure it's in the Q&A panel because otherwise I might not have time to get to the chat window. All right, exhibitions. Why does this matter? You're probably not an artist, but you might be a product designer or product manager. This matters because there's sort of this tacit reference in the language that says, like, I haven't touched the exhibitions criteria probably in like 5 years because I got so many nasty RFEs when, at that time, when I tried to use like, look, this car design for this car of the future was showcased at a major mobility conference. And they were like, no, it's not artistic. You can't use it. So they made a slight change, and it's more about that there's a strategy for how we can use this rather than what the plain language says. So the change they made says for comparable, okay, in criterion 7, where they talk about the display of somebody's work in the field of artistic exhibitions or showcases, it does acknowledge that you have to have, the laws requires that it has to be artistic, and they can't get rid of that here. But they do leave this handy dandy, like breadcrumb, right? Like Hansel and Gretel following the trail in the forest or something. They write in that criterion, USCIS only considers non-artistic exhibitions or showcases as part of a properly supported claim of comparable evidence discussed in more details below. So to me, in my mind, as I read this, the way my lawyer brain processes this is like, sweet, they're telling us that anytime your work is displayed anywhere, we're going to knock it over in the comparable evidence thing. We're going to say that tech doesn't have artistic exhibitions, but hey, look at this, in tech, there's these other type of showcases, and this is where your work was displayed, and we're going to use that. So that's another super exciting thing that we can now do. Okay, so a few quick words on how to apply if you're interested. So first we have to assess your eligibility. You know, what are your achievements? Have you gotten them recognized? What types of evidence do we have? What are your plans to continue working in your field in the future? How is this going to help the United States one day? These are all really, really important things to discuss in advance on a consultation call with one of my colleagues or me. So we can really like look at, you know, where are you now? Where do you want to be? What are your goals? Is EB-1A even the right strategy to consider? Because there's a bazillion immigration creative things we can do to help people. So like if your goal is to launch a startup in 4.5 months, we're not going to choose an EB-1A. There's going to be better, faster things to help you with that. So we have to have a conversation, and we frame your goals, your field, your current evidence, if there's a delta with any evidence that you need, and then like what your timeline is, what your travel considerations are, what your family considerations are, because all of these are really important to building an individual strategy specific to you and your life. I do have an online prep course for people who are like super at the beginning of this process. We're going to be sending out the email link to everybody in the follow-up email, but people love it. It's helped a lot of people get green cards. It's 15 videos that I recorded that are pretty comprehensive, looking at all sorts of requests for evidence that I got from a bunch of cases, explaining where this RFE came from and how to avoid getting one in the future. So people have said, like, of course, there's like a lot of masterminds and stuff for evidence prep, but people have told me that that is really particular, and there isn't that type of information anywhere else out there on the internet. We have an additional offering, which is a 4-week assessment and evaluation process. So when people talk to us, not everybody is ripe for getting a green card right away, or we might have questions like, yeah, you talk a big talk, but let's put your money where your mouth is. Can you really deliver the docs to us so that we can prove out your extraordinary ability case? So like in general, for an EB-1A petition, we charge $11,750 flat fee upfront, regardless of how many criteria you're doing. If there's an RFE, it's separate. We have an option to get extra help on the letters of recommendation called our white glove letter writing service. That's an additional $500 a letter, is not required. Even if you do our basic standard process for $11,750, we will do a detailed case strategy meeting with you, review your recommender snapshot, give you our templates and sample letters, instruct you on which letters need to have which information. You can generate them. And then we'll edit them to make sure they're up to our standards. So we're going to help you put your best foot forward, and our goal is just to get you approved. I don't want to deal with RFEs. I want you to just be instantly approved and tell your friends what a great experience you had. So that is how we work. But not everybody is ready for that. And so some people are like, I'm not sure if I'm ready. Other people are like, well, I know I'm not ready, but I don't know what else to do. So that's where I created Legal Launch, because people need help figuring out how to become qualified more than an online class. And so if you do this 4-week program, it's $2,500. We give you our checklist, you upload all your information, we do our 3-layer internal review, we prepare the case strategy, and you have an attorney meeting to review, am I qualified now? Shall we go ahead? Or here's your personal checklist of the things we recommend you do in your field to close that gap and to become fully qualified. And if you can do that in the next 6 months, we'll fully credit the $2,500 to the $11,750 petition fee when you're ready to get started. Filing fees are separate. Filing fees are now $1,015 for an EV1A plus optional $2,805 for premium processing, but we typically recommend premium processing. It just gives our clients a lot more peace of mind. Okay, so in a minute, we're going to go to Q&A, but I'm just going to leave my contact information up here while we do that. And my book is available on Audible. If you like hearing my voice, I recorded my voice in the same podcast studio where Reid Hoffman records Masters of Scale in Palo Alto, so that was fun. But it's available on Kindle and paperback as well. And the one big caveat I would say is I have to update the section on the employer-employee relationship for things like H-1B and STEM OPT and E3s, because there were other changes that now allow people who want to own. I'm not going to, this isn't the focus of this webinar, so I'll try to say it clearly and succinctly, but let's say you're on an H-1B and you want to start a company and you want to transfer your visa to your company. Used to be you'd have to get like a 3-member board and get an American and blah, 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 get rid of your equity. A lot of people got screwed that way. Now we've had positive affirmatory guidance for over a year from USCIS, and we've had multiple successful client approvals where we've been able to get them H-1B approvals, even if they own 100% of their startups. So you no longer have to give up equity. So it's really, really important. Okay, but now I'm excited to go into the questions. All right. I'm just going to try to get through as many as I can. And if you need more information, here's all the contact info, obviously, to follow up. Okay, number 1. Pratik, thank you, Pratik. Do GitHub repo contributions, reviews count as evidence? Yes, if they're like public, and ideally it's easier to show all this stuff with open source software, but it doesn't have to be. There might be associated things you can do, like be in some nonprofit board related to an open source project that can also help. But yes, we've absolutely used GitHub information for past clients who have gotten approved. So do consider that if you have it. Next question. How does the recent clarification of team and company prizes work? Can I use the prizes that my employers, Brex, Microsoft, etc., won? What all prizes can be applicable here? Funding, TechCrunch lists, CNBC top 50, etc. Well, as I mentioned, it sort of depends on your role. If you are a founder or like a founding engineer or like a founding level employee, we have years of success helping people with those types of organizational responsibilities to qualify, which is pretty cool. So I would say, like, yes, we try to use all of that. Now, technically for the team updates, it does say that your name has to be listed on the award website. But let's face it, there's a whole bunch of company prizes that never mention anybody, including the CEO. And what do we do practically in those situations? We get letters of recommendation tying your contributions and responsibilities in the team to the awards. So when you're reaching out to us, that is critical information we want to know when your employers won awards, especially if we can connect it to your work. And the corollary is even for published media about your work. Like if you built something for Amazon, you're not going to be listed in the press release or in the New York Times, but your product might be. So we've been able to tie that in for people all the time. So when in doubt, like, give us more, not less. We will gladly filter through it for you. Next question, are the new changes only for EB1 or are they applicable to the O1 also? They're technically only for the EB1, but we have a very compelling argument that anything that counts for EB1 can also count for O1. So if one of these evidentiary criteria is like make or break for you about whether you're qualified, but what you want is an O1 first, I'm sure we can make arguments tying it all in for you. So like, please reach out. Next person asks, I am targeting two specific criteria, judging and publishing scholarly articles. What events count for judging and how can I get these judging opportunities? Are paid articles acceptable in the scholarly articles criterion? Okay, first let's take judging. At the highest level, my layman's term definition of judging is, are you chosen as an expert who gets to decide who else is an expert? Now, is that the law? No, but that is how I practically think about this criteria. So it depends on your field. If you are a scientific researcher in a university research lab, your judging is probably going to be peer reviewing other people's work or being on conference committees. If you are a developer or a serial entrepreneur, your judging is probably going to be in hackathons or maybe pitch competitions or other industry competitions. It really, really, really depends on your industry. You know, I've made arguments. We help venture capitalists with EB1As, and one of the arguments I make for them is that their whole job is judging. So it really depends, but it has to be related to your field. And I go into that in the online class, Extraordinary Ability Bootcamp. This second part of this was, how can I get these? You know, this whole exercise is actually a wonderful exercise in personal brand, thought leadership, marketing, and networking. When I started my law firm out of my kitchen 9 years ago, I had been a stay-at-home mom for 4 years. Even though I had gone to Stanford, I had moved away right after and didn't have any professional network in the Bay Area. And I found that I needed to build up a professional reputation to create my law firm fast. And I was doing all types of immigration law, including asylum and removal defense. But I really wanted to work with super smart people in the Bay Area and around the world. And I was super intimidated that you guys wouldn't think I was smart enough to do your EB1A cases. So I was like, well, I'll prove it. And I literally used the EB1A criteria as my personal and professional marketing plan for my law firm for the first several years. And it's worked. Like, we've grown a lot. We've been able to help a lot of people. So this is all about you, your relationships, positioning yourself, saying yes to things, volunteering, asking people for help. It can be uncomfortable if that's not your comfort zone, but the rewards are truly great. I even had one client who got an EB1A. She wrote a bunch of articles in an online product management journal, and it led to a book deal. And now she has like a global bestseller. Plus, she teaches all these online classes that people pay her for based on what she had to do for EB1A. Now, the next part of this is, are paid articles acceptable in the scholarly articles criterion? So I'm going to tell you two things. One is, paying a magazine to publish your work will not work because USCIS doesn't want marketing materials. That being said, some people do occasionally use publicists who help them get placements, and those can work. But I don't actually recommend any specific publicists at this time. I think that you have to do that own research by yourself and just be very, just have a lot of integrity through the process. That would be my recommendation. Okay. What is the difference between the EB1A and the O1A for a self-employed person who wants to work with an agent and different clients in the USA? Well, that's a great question. So the O1 with an agent is wonderful because you can basically be self-employed in your field at the visa stage, not even having a green card yet. So we do O1As for people with agent petitioners all the time. They charge $1,000 per petition. It's no big deal. And you can build your startup, you can do consulting, you can have side projects. The EB1A doesn't need that because you can self-petition for an EB-1A, unlike the O1, and the EB-1A is simply a green card. So after you get it, you're just a permanent resident. Like, you're supposed to do what you said you would in your green card petition, and they can check on that in your citizenship interview one day, but you don't have to get all of your employment checked all the time. So you don't need an agent for an EB-1. But if you're comparing the two and you're like, well, I need to work in the US in 6 months, definitely do an O1 with an agent first and then do the EB-1A after. Do you have any predictions for when EB2 and EB3 priority dates would reach the beginning of 2015? I don't, I'm sorry, this is so sad. It's been such a long, frustrating wait for so many people, and my heart goes out to you. I don't know. What I can tell about this fall's visa bulletin with the new fiscal year, I was hopeful they would have some like massive release and all the numbers would move forward, but they're being slow and cautious. So I think that they're gonna piecemeal it out, trying to gauge how much demand there is, you know, throughout the beginning part of this year, throughout the presidential election and into the new term, to see, because they don't like wasting the visas, but they you don't want to lose them all at the beginning of the year either. All right. If I apply for an O1 with your firm, will it be for 1 year or 3 years? Well, the initial O1, we can always request 3 years. After that, the easy thing is to get 1 year extensions. But if there's some change where we can request a new O1, we could easily get 3 years as a second O1. But during the prior Trump administration, we didn't want to do that because there was too much risk involved. So most people were doing 1 year O1 extensions during the prior Trump administration and then upgrading to EB-1A as soon as they could. What about technology? Does it fall under sciences? Yeah, it's like a hybrid. It's like science and business had a baby. So we use it. Next question. I work in a big tech company and work on a popular ad product. I don't have patents or research papers, so external people wouldn't know I built the tech behind this popular ad product. When asking for external letters of recommendation, how can external people justify they know I built this product? Or do they not have to give any justification for this, and they only focus on talking about the merits of the product and the tech? This is very nuanced, and it goes into our recommender snapshot phase of our case strategy when we help our clients. In my mind, there's like a matrix, which is like all of the types of evidence and all of the things you have to prove it. So if I notice like a gap in original contributions because you built this really cool thing, I'm going to be thinking about letters of recommendation, some internal to the company proving you worked on it, and some external to the company proving that it's significant. And we can do it that way. On the no job employer letter required, does that mean one can be outside of the US and still apply for the EB-1A? Absolutely. I didn't have this slide today, but normally I state there is no requirement to have a visa before getting a green card. Now, starting a green card process, if you've never had a visa, it could jeopardize your ability to get your first B1, B2 visitor visa. But if you're not planning on visiting, or if you have a 10-year B1, B2 and you're outside, yeah, you can do this whole process from outside the United States as well. I covered filing and attorney fees. If Trump wins, how likely is the new EB-1A guidance to change by the end of January or February 2025? It is extremely unlikely to change. These are minor changes that are non-controversial. Like, in some sense, they just removed some illegal statements that were incorrectly in here before, so you can't actually add them back in. There's also a timing thing. Their first, I don't even know if this is true, but okay, wait, let me just start saying this. Well before Biden and AI becoming popular, the Obama national security policy, the Trump national security policy, and the Biden national security policies all agree that recruiting and retaining the world's most brilliant people to live and work legally in the United States and build the technologies of the future, that's like a #1 on the national security priorities list. This is all related to that. Is that very likely to change in a Trump administration? Not at all. Even if it were on somebody's list, which, you know, Trump is actually much more in favor of immigration than like Stephen Miller, who used to run it in his prior campaign, and he's changing out people. He even went on the All In podcast and said something Hillary Clinton said once, which was like every immigrant should get a green card stapled to their community college diploma or something. So, but let's just assume somebody wanted to change all this. It's going to take several months, if not years, to get around to making all the changes. So this is very safe. For founders who want to apply for the H-1B visa as a transfer, what criteria can we aim for EB-1A, such as critical role, income? Would they be enough? Well, when we're looking at founders, we're typically looking at several things. So like, did you get angel investment or venture capital, or were you in any accelerators or incubators? Because we can use all that for prizes or associations. Is there press coverage about your startup and how you founded it? We can use that for the media, the published material section. Did you judge hackathons and pitch competitions? What is your technology that disrupted, and like how fast is it growing? That would all be original contributions. Have you written any like magazine articles like Business Insider, Entrepreneur, Forbes, something like that? That can be authorship. Obviously you would have a leading and critical role and a high salary based on your equity imputing the value of your company. So if you've had a price round, that's more compelling evidence than like a safe note. But yeah, you probably have, as a founder, you probably have a variety of evidence. The next question is from somebody who's visiting on a B1, B2. Should they apply for an O1A in their home country, or should they apply for it while being in the US? What is better and why? It depends on if you're married and have kids back home. When did you arrive in the US? Did they give you a full 6 months? Do you have a return ticket? When are you planning to leave? How much money do you have? I think it's at least worth a conversation early in your B1, B2 visit to determine this. But in general, it takes us usually 10 to 12 weeks to prepare and file an O1 petition, an EB1A petition. We haven't talked about it as much, an EB2 NIW petition. So I think it all depends on the timing. Ideally, I would want you to have your O1 approval before the end of your 6 months of B1, B2 if you're going to go this route, but you would still have to do visa stamping back home after this trip. Who is considered a founder? Does starting a self-supported bootstrap startup LLC without employees count as being a founder? Yeah, the immigration law doesn't care about founders. I just work with founders, so I like figuring out how to make stuff work for founders. So if you're bootstrapping something, I consider you a founder, and we can try to use as many of these tools as possible to help you, but it's not like a legal definition. My company does normal green card processing, and I haven't gotten the perm approved yet. Can I file for a concurrent H-1B visa without restarting the green card process? Maybe. It might be safer to wait until the perm is done, or at least to make another strategy about EB2 NIW as a self-petition. But that's certainly something where we would want to have a conversation. And the other thing I would advise anybody considering a part-time concurrent H-1B, like 5 hours a week to build your own project, especially in big tech, you probably signed a confidential information assignment agreement when you got hired, which basically means you keep all the company's information secret, and anything you build on company time or property belongs to them. So there's a variety of reasons why you might not want to get a concurrent H-1B, but there's other solutions for that as well. I'm loving all these questions. You guys are so smart. Okay, 9 minutes. Okay, here we go. I'm a senior manager for engineering technology solutions working for an EPC company. Part of my job is to do a technical scope review and approvals for a lot of automation that my team develops for the business. Does that qualify as judging other people's work? It might. I don't know what EPC is. If they're of external stuff, it might be more helpful. I did get RFE in the past because I tried to say that Google internal employee performance reviews were judging, but they were not counted as that. So it's better if it's somehow external in some way. To qualify for the published media about yourself criteria, would 3 articles in the last 3 months be good enough to meet this? Since I'm building my profile from just a few months back, is there a chance to meet the published criteria with all the articles being recent? Yes, but we want to show, you know, the whole impact of your work in the field over time. So if there's other things you did before, we'll try to tie that in to show that you have some longevity to you. Are special stock awards considered an award? Potentially. We also can use them as high remuneration. It depends on the context, how many people get them, how many people are eligible, but we've certainly used select internal company awards as awards if we can show that they're comparable to something very significant. Can you clarify who is eligible for the award criterion in startups? Are founding engineers and designers also included or just founders? We have successfully gotten that approved for founding engineers and potentially founding designers in the past, so it's worth taking a look. Do you have to be acknowledged as a recipient of an award by the awarding committee specifically, or is it enough that the team receive the award and then provide that I'm part of the team, perhaps as through a recommendation letter as example? So this is where the new policy manual says that your name should be listed, but in my experience with nobody's names being listed, we tie it together through a letter of recommendation. How much venture capital is sufficient for a founder or a CEO for the award clause? Is a $3 million seed round raised by the founder of the company sufficient? Absolutely. I've done it with like $200,000 from some angel. If I'm a part of a university research group, which is usually hard to get into, would that count as a membership? Probably. For instance, I hold a high position at a big tech company and also am a principal investigator in a machine learning research group. Yeah, I think so. Or we can probably use that in multiple ways. For published materials, does the article need to explicitly mention the applicant's name, or is it enough that they spotlight your work? Ideally, it would mention your name. Ideally, you would win Time Magazine Person of the Year and they would do a 10-page article on you with a photo shoot. But like, if not, in an article about you would be great. And if not, like an article quoting you would be great. And if not, if it's about your work and we can get a letter of recommendation saying you did the work, we can try to use that. We've been successful at that before. Does appearing on a podcast count as a publication? It can. That is where we need to tie in that the publication is either major media or like considered like the equivalent of like a scholarly research journal. So we would need more information on the podcast and the number, like the amount of streaming and the listenership, but we have made that argument in the past. Do patents count as awards? I'm curious if people argue it this way. We typically use them for original contribution, but then we also have to show that the work has merit and it's in commercial use for that argument. But I would be open to consider making the award argument for you. Does speaking in conferences presenting my work count under exhibitions? And does speaking in conferences replace the criterion of published material? I mean, we're lawyers. We can do this in any way we want. In my experience, that works best as comparable evidence to authorship when you're doing a lot of speeches. What are some of the criteria that you tend to see the maximum RFEs and recommend avoiding? I would just say that like Globie Awards and Stevie Awards and some of the other stuff like that people have been doing heavily since January, they have started to lose their pizzazz. So if you have a lot of those, that will probably anger the officer and could trigger an unfair RFE, even if you have other good stuff. So we're actually excluding those types of things that are overused now from some of the petitions. Can product designers combine technical and artistic criteria, including exhibitions? Absolutely, do it all the time. Happy to help. This person has 2 books related to AI/ML that are published. Will showcasing them in any book fairs or exhibitions help to fulfill the exhibition's criteria? What evidences should we provide? It might help if somebody's going to charge you a lot of money to do it. I don't know if that would be worth it, but we would basically be using that new comparable evidence argument, saying that in the publishing industry, book fairs are the equivalent of artistic exhibitions, and this is a top book fair in the world, and look, you exhibited your books, if that's true. Another law firm has a different offering. What is it like working with Alcorn? I mean, we are friendly, kind people who are actually helping you, right? So I don't know other law firms and their systems and their turnaround times and their prices. But I would say when you have a consultation with one of our attorneys and we're evaluating, like we generally want what's best for you. And I turn people away all the time because I don't want to waste their time and money. And that means that we have like even though the RFE rate went to like 30% for EB1As throughout the year, our approval rate this year went from like 97% to 98.5%, which is way higher than the national average. And I think it's because we're very conservative and very strategic. So like if you want the fastest, probably don't come to us. If you want the cheapest, probably don't come with us. But if you want the best chance of approval, that's probably, the right match. How is high remuneration evaluated? You have to be at the top of your field. The 10% thing is erroneous. We just need evidence that you made a lot of money compared to other people at that time in that place for that type of job. We can use a lot of types of evidence to prove it. Oh my God, I'm not going to be able to get to all these today, everybody, but I really hope you email us if you have any other questions. You can just shoot us a direct email to hello@alcorn.law and say you attended the webinar. Here's your additional question. We'll see if we can get you the answer. But also, we're going to be sending out this recording and some additional materials to everybody who registered in the next day or two. But really, if you want help, the best way that we can actually get you the right answer is to scan the code and fill out our request for a consultation and to complete our questionnaire. And that's going to allow us to be the most comprehensive in the type of evaluation we can give you and the types of answers that we can give you. Okay, I'm just going to check one more thing here. Okay, yeah, try to answer just a couple more and then I gotta go. This is fun though. Thank you everybody for staying with me. Let's see who's next. What is the time estimate to file an EB1A petition with Alcorn if one is ready to file? We give you 6 weeks to give us all of your evidence, including the signed letters of recommendation, and then we have 6 weeks to prepare and file the petition. EB2 and IW, same thing as EB1A, $11,750. Does exhibition of a company banner as a sponsor of an event count under an exhibition? No. Marketing materials probably doesn't. If I have an approved O1 with the help of your firm, will you be more confident in filing my EB1A or EB2, or will I have to justify my extraordinary ability again? No, we'll help you. We'll give you a discount. We'll reuse your stuff. We'll want to know the new things, but it'll be easier. Does your name have to be listed on a top tech company blog count as a scholarly? Like if you wrote like a Google blog, we're absolutely going to use that as a scholarly article, if that's what you're asking. Aside from the fees, any advantages to processing through a company attorney versus self-sponsoring? If you love your job and you have a company that's willing to do this for you with a great brand where you're happy to work for a long time, do it with your company. That's great. But if you want to quit, or nobody knows your company, or they don't necessarily have an immigration lawyer that's qualified to do this, then it makes sense to consider doing it on your own. Oh my gosh. Okay. Well, that was so fun. I wish I could have answered all the questions. We got through 40 out of 60. So that's 2/3. So I will consider that a success. Thank you so much for joining me today. Have a wonderful rest of your day. Thank you for listening. Thank you for being here. Thank you for your questions. Connect with me on LinkedIn, and we look forward to keeping in touch. Thank you all so much. Have a great day. Bye.